Hello everyone, I am Akash Srivastav, your law mentor, and in today's Law Wednesday session, we are going to discuss very important topic, that is will laws in India. So without wasting time, let's start the session. So when we talk about will, this is one very important and very common concept. Everyone knows about it. What exactly is a will? You must have seen or you must have heard about this particular term in movies also, in your family discussions also. So in today's session, what exactly we are going to do? We are going to discuss the technicalities of the will. What exactly there should be in the will? What are the restrictions in a will? And few common questions related to the will. So let's start the session. So the first thing is the meaning of the will. So general understanding what exactly will means. So it is a legal document by which a person, the testator, so the person who is making a will be known as a testator, expresses their wishes as to how their property is to be distributed. So when we talk about property of any particular individual, so if he wants that particular property needs to be distributed in any particular format, in any particular manner, then for that he can make a will. At death, so we are talking about the property needs to be distributed at a later stage when the person is not in existence, at his death, and names one or more persons, the executors. So for executing the will, he can name one or the more of the person to manage the estate until its final distribution. So till the final distribution is done, the executor will be managing the property. So overall understanding of a will is that if I want to distribute, I want to pass off my property at my death, so how exactly it needs to be done, to whom the property needs to be given, everything, every detail will be given in the will. A will made by a Hindu, Buddhist, Sikh or Jain is governed by the provisions of the Indian Succession Act. So Indian Succession Act 1925 governs the will that is made by Hindu or Buddhist or Sikh or Jain, because all the four things that I mentioned, that Hindu, Buddhist, Sikh or Jain, are considered as Hindu according to the Hindu Marriage Act under section 2. However, Mohammedan are not governed by the Hindu Succession Act 2025 and they can dispose their property according to Muslim law. So there is a separate law for distribution of property for the Muslims, but when we talk about Hindu, Buddhist, Sikh or Jain, they are governed by section 2 of Hindu Succession Act, through which they can distribute the property. So will is defined under section 2 clause H of the Hindu Succession Act 1925. So this is the general understanding of a will. Let's move ahead and discuss what exactly needs to be there in the will. So key ingredients of a will are, the first one is details of the testator. The person who is making a will, all the details. So what exactly is the name, the person's age, everything will need to be given in that particular will, through which we can identify that particular will was made by that particular person only. So there should be no confusion in that. The second thing that is mandatory is will should be the format of the legal declaration. So it's very important to understand when we talk about will, it's not a contract. So it's a declaration. I am declaring that this particular property needs to be distributed in such a format. I'm not agreeing with anyone that, okay, this is a contract between the two of us and the property I am distributing, I'm giving my property to you. This is not a contract. This is not an agreement. It's a declaration. I'm declaring that the property needs to be distributed in such a format. Next is intention of the testator should be clear. So when we talk about what exactly, so the person who is making a will be known as a testator. So the will or the intention of the testator needs to be very much clear. So if he is distributing his property to someone, it should be pretty much clear by reading the will deed. Next is the details of the beneficiary should be specified. So all to whom the property needs to be distributed at the death of the testator, all the details of the beneficiary should be there. Next is desire of the testator should be clearly mentioned. So when we talk about will, one particular person is desiring that after his death, the property needs to be distributed in such a format. So the desire should be pretty much clear. It should not be ambiguous. It should not be unclear in nature. Next is details of the executor of the will should be there. So if you are appointing any particular person to be the executor, all the details of that particular person should also be very much clear and should be mentioned in the will. And the last one is signature and the date. So these are the few of the requirements that should be there in the will, but again this is not a mandatory condition. These are few of the things that will make a will a valid will, a very clear will, and it will not create any confusion at a later stage. So these are the key ingredients of a will. Let's move ahead. Now, when we talk about will, there are n number of types of wills. So few of the common types of wills are, the first one is privileged will. So what exactly is privileged will? So if the will is made by any particular person who is in an army or at the mariner at the sea. So mariner at the sea and army person, these are the two categories of person who can make a privileged will. So there is different separate category of will, and only these two categories of person can make a privileged will. The next one is unprivileged will. So all the other persons will be making an unprivileged will. The third one is handwritten will. So when we talk about will, it is usually recommended that it should be typed, but if any particular person is writing on its own, in his own handwriting, then that will be known as handwritten will. So at times it may create confusion. It may create say conflict that whether this particular will was made by that particular person or not, because the court needs to assess whether the handwriting in which that particular will was written was of the testator or not. Next is mutual and joint will. So at times it happens that if I want to distribute my property, I will be making a will. But if two of us, so for example, it usually happens in the case of a spouse. So if husband and wife want to distribute their property, they can make a joint will also. Next category of will is contingent and conditional will. So if there is any condition attached to the will that if this particular event will happen, then only the property will be distributed, or any condition attached to the will that only after this happening the property will be distributed, or after this particular person will be getting the property. If there is any condition attached to the will, then that will be known as contingent and conditional will. Then the next one is statutory will. So all the details of the what exactly needs to be there in the will is given over there. Only the filling the blank will be of the name of the person or details of the property will be there. So it's a set format, it's a fixed format. So that will be known as statutory will. Next one is advance medical directive. So again, this is not a kind of will, but again, it's when we talk about will, what exactly happens that after the death of the person, the property needs to be distributed. But when we talk about advanced medical directive, this is also commonly known as living will. So what exactly happens in this? So the person is directing, if in case the health of the person, the health of the testator is deteriorating or is becoming very bad, so till what extent the doctors are permitted to take an action against him. So what all procedures he can mention, how much property needs to be invested in the medical bill. So everything can be given in the advanced medical directives. Next one is unsolemn will. So if you are appointing an executor for executing your will, then that will be a privileged will or unprivileged will. But when we talk about if you're not appointing any particular executor for executing your will, then that will be known as unsolemn will. Next one is testamentary trust will. So if you are giving your property to trust also, then in that case, I'm not only saying that you are only distributing your property to trust only. If you are giving the property, and so for example, if you are giving property to 3 of your sons, and you are also including one trust in that case it will be known as testamentary trust will. So these are the few of the types of will, but when we talk about, there will be n number of other types, but again these are the most important ones. Let's move ahead. Next one is restrictions on a will. So when we talk about will, there are few restrictions on the will, which type of property can be distributed or the manner in which the property can be distributed. So the first will is that transfer to unborn persons is invalid. So when we talk about can I transfer my property to any unborn person, in that case if I'm transferring through a will, that will be invalid. First of all, I need to create a life interest on someone who is existent at that point of time when I am dead and the property needs to be distributed, and post him I can give the property to the minor, so unborn person. So this is the first restriction, that you cannot directly transfer your property to unborn person. So you need to create a life interest on someone else. So the second point is that transfer made to create perpetuity. So when we talk about disposing of property after that of the person through a will, you cannot dispose of property in an unending process. So you cannot distribute the property saying that it will pass to person to person to person and only creating life interest and not going to one particular person at the end. So that is not permissible according to will law. Next one is transfer to a class, some of whom may come under above rules. So if you are transferring a property to say multiple people and one or the other people is coming under the class that we have discussed earlier, so for that particular person the property that will be going through will be invalid, but for other people it will be totally valid. And the last one is transfer to take effect on failure of prior interest. So for example, if I have distributed a property to someone according to a bill and that particular distribution is invalid in nature, and I have also said that post that particular person the property needs to be given to the third party. So if the prior transfer is invalid, the later transfer will also be invalid. So these are the four restrictions on a will. Let's move ahead. Now, when we talk about will, we have discussed that what are the key ingredients of will, what are the basic meaning of will and types of will. Now we need to discuss what are the grounds on which we can challenge will. So if there is any particular will made by a person and we are very suspicious or we are not very sure whether this is a valid will or not. So on what all grounds we can challenge it is mentioned over here. The first one is fraud. So if you can prove before the court of law that the will was made by fraud, then that will be an invalid will. Coercion basically means if you are using any crime that is mentioned under IPC to make the other person to make a will, that particular will be known as will formed by coercion. That will be invalid will. Next one is undue influence. So if there is any particular person who is in a dominating position and using that dominating position to make the other person to make that particular will, and through that particular will, the person who made the other person to make the will is getting unfair advantage. In that case, you can prove, if you can prove before the court of law that will was made due to undue influence, again the will be invalid in nature. Suspicious nature, when you see a will and you see that there is something suspicious or there are multiple signatures or multiple thumb imprints or there's something wrong, if you can prove before the court of law that there is some suspicion involved in that particular will, again that will be a valid ground for challenging a will. Next is lack of due execution. So if the due execution is not there, if the signature is not there, or the sign of the witness is not there, again you can challenge that particular will before a court of law. Next one is lack of testamentary intention. So the person who is making a will, if there is lack of intention on his part to make a will and it can be proved by reading the will, then again it can be a valid ground for challenging a will. Next point is lack of testamentary capacity. So the person who is making a will, he needs to be capable enough to distribute the property for which he is making a will. If he is not the owner, if he is not a capable person to do that in a very good capacity to do that, in that case that can be a valid ground for challenging a will. Next one is forgery. So if you can prove before the court of law that that particular will is not a valid one because there's some forgery done to that particular will, in that case again it will be a valid ground for challenging a will. The last one is revocation. So if you can prove before the court of law that this is not the last will and it was revoked by a new will, again it can be a valid ground for challenging a will. So these are the few of the grounds on which a will can be challenged if it's not valid in nature. Let's move ahead. So again, when we talk about will, so these were the few of the important pointers related to will. So there are few questions that may be very common and that may be coming to your mind when we talk about will. The first question is whether a registration needs to be there for a will. Again, the answer is that no registration is required for a will. If you are registering it, it will be a smooth process to prove before the court of law for the person to whom the property will be distributed. But again, registration is not required. Can a testator change his will? Definitely. So you can make n number of wills and the last will be a valid one. Next one is place of making a will important? No, it is not important. Is there any fixed format for a will? Usually it is recommended that all the details that we discussed, the key ingredients of a will, should be there in a will. But again, there is no format of a will, no fixed format of a will. Next one is it mandatory to number the paragraph? Again, it is recommended that you should number it. But again, if you're not doing it, it's not mandatory in nature. And the last one is, can benefit to natural heirs be denied through will? Definitely. So this is the purpose of will, this is the objective of will, that if you don't want to go through the usual process according to Indian Succession Act, that how exactly property needs to be distributed after your death, you can make a will and can decide in which manner or to whom the property needs to be given. So these are the few common questions. I hope the concept of will is very much clear to everyone. So we discussed key ingredients, we discussed what exactly will means, what are the types of will, restrictions on a will, and in last few common questions. I hope the session was informative enough, guys. Thank you very much. This is all from my end.